civil society groups, including Equal Education, Section 27, Centre for Child Law and the Legal Resources Centre, are calling for key changes to the Basic Education Laws Amendment Bill, or BELA. Now, the BELA Bill was introduced in Parliament in December 2015, December 15, 2021, and the committee has received approximately 18,000 written submissions to date. On Tuesday, the Basic Education's Portfolio Committee met again to discuss the progress in processing the public submissions. Now, the committee will next week start with oral submissions, and Equal Education and the Equal Education Law Centre will form part of the first round of oral presentations. Parliamentary researcher for Equal Education, Jane Borman, joins us now for a conversation just to bring all of us, up to speed and getting to understand what the bill is intending to do. So, Jane, good morning. Thanks so much for joining us.
Morning. Thanks for having me.
So, Jane, the bill is looking essentially at two pieces of legislation, the South African Schools Act of 1998, as well as the Employment of Educators Act of 1998, and proposing to align these two with developments in the education landscape. Now, it all sounds good and well, but what are some of the misgivings that civil society has with some of the proposed amendments?
Well, one of the biggest and one that I think garnered a huge amount of public submissions is an amendment that will allow for the sale and consumption of alcohol at school functions. I mean, obviously there are limitations to it, but essentially, this means that outside of school hours, there can be the sale and consumption of alcohol by adults for fundraising purposes. I mean, this is something that, alcohol abuse is an issue across the country, and many parents that we've spoken to and other community civil society organizations are worried that this is going to make the fight to keep their children safe much more difficult. We also have concerns around the fact that they are wanting to increase the jail sentence for parents and caregivers who are unable to get their children to attend school regularly. This is also a big problem for us, obviously, because mostly the issues that hold parents back from making sure their children are at school are issues such as poverty, insecurity, other barriers of access, and we feel we need to tackle the real issues rather than put parents in jail.
So I was reading through some of the comments that you've made, and, actually very useful in how you've broken it up and given your comments as Equal Education and others to this. But perhaps for those who will not have an opportunity to run through it, Jane, if we can maybe just break down some of the misgivings that you have and also some of the proposals and comments at this stage. Now, you will be in Parliament next week presenting Equal Education's thoughts on these proposals, and they include, of course, the power of the Minister to determine the curriculum and assessment policies, corporal punishment, the legalization of alcohol that you just pointed out during fundraising events. Also, you just spoke to the prison terms. But let's talk about the powers of the SGBs to begin with, especially as it pertains to the appointment of teachers. And we've seen in some instances where these situations have really gotten out of hand, where communities have been unhappy about the appointment of certain teachers. So let's talk to that, the powers of the SGBs in that regard.
Yes, and the new BELA Bill addresses a number of issues regarding school governing bodies. Like you said, most of this is bringing the new school laws in line with existing court orders, and so a lot of it is not necessarily the Department of Basic Education making up new policy, but rather sort of following existing requirements from the courts. But we see it in a number of issues. Like you said, there's the teacher's appointment. We are also, has been a big public debate, but we are welcoming the amendments regarding language policies, meaning that the Department of Basic Education, heads of department, will have greater oversight of schools' language policies. We have unfortunately seen language policies used as a way to racially discriminate against learners and exclude learners living in the area of a school from accessing the school. This is something that obviously is unconstitutional and is something that really needs to be fought against. And we believe the BELA Bill is an important first step. We also do want the BELA Bill, and this is one of the amendments that we are asking for, to clearly state in unequivocal terms that no learner can be refused access to school, a school within their area based on language policies. We also want to make sure that discrimination from language policies can be picked up earlier on, and so we want the Department of Basic Education and heads of department to have greater access to the language requests from applicants, not just people admitted to the school, not just learners admitted. Like you said, there's also the issues of teachers' appointment. We are welcoming further amendments, such as requiring financial disclosures from school governing bodies, because we feel that this will really help in the fight of making sure that school governing bodies members aren't able to enrich themselves. So we are seeing a number of changes that we are pleased about, but we are wanting to make sure that this first step made in the BELA Bill is really strengthened by provisions which clearly state the intention.
And I would just imagine, Jane, the issue of language policy at a school is one that obviously will be debated fiercely, and won't be surprised if it lands up at the Constitutional Court at some point. But what I've noticed in this regard is that parents don't seem to know and understand their role in determining language policy at school.
Yes, and I think one of the big, for us, there are many layers to this issue, and as Equal Education and Equal Education Law Centre, one of the main points that we are really wanting to drive home is to make sure that parents whose children live in the area of a school and don't have alternatives or other adequate alternatives are not denied access to a school based on the learning requirements. And it's important that parents also understand that, because what you will be seeing is, in terms of admitting learners to school, there's a situation where a school can say that they are open to all learners, but turn learners away in their application process based on language. And it's important in that process that parents know that is unconstitutional, and that they know that their child has a right to access a school in their area that has the adequate resources. And so, a part of what Equal Education is doing across the BELA provisions is we are really fighting to make sure that parents and learners are empowered to know their rights, not only under the BELA Bill, but obviously under the Constitution. And, we will see a little bit later on, there's going to be public hearings where the committee will be going to different communities, and Equal Education members and parents are already getting ready for those, and we'll make sure that their voices and their stories are also heard, because obviously as parents it's vital that they understand and get to express their concerns and frustrations.
Jane, the issue of corporal punishment, now, it has been abolished in our schools, but I see you say here Equal Education and EELC welcomes the inclusion of a definition for corporal punishment in Section 1 of the bill. Now, let's just speak to why this is important, because what are we grappling with at the moment as far as corporal punishment in schools is concerned?
Well, I think that what's important and what this bill does is it acknowledges the multiple aspects that can feed into a learner feeling punished by teachers, by principals, by schools. And we think it is really important that under this definition, we recognize the multiple and sometimes more subtle ways. We have as a country grappled more strongly with the ideas of physical corporal punishment that are more direct and more obvious. But we really want to make sure that learners who enter the school space are safe from all forms of harmful punishment from from teachers and from any other school administrators. And so we really want to make sure that, schools are a safe space for learners. Obviously, we understand that there needs to be, certain repercussions if learners are not behaving, but we firmly believe, and we feel that this BELA Bill addresses the fact that there are multiple ways that learners can be unfairly and detrimentally punished.
So just to read your recommendation here, it says, we recommend that the current definition of corporal punishment in the BELA Bill also include other non-physical forms of punishment, which includes a threat of force. Please elaborate.
Yes. So again, for us, we really want to make sure that it is understood by schools and by teachers that there are multiple ways of intimidating and unfairly punishing a child, and that, while the definition of corporal punishment is important, we also need to acknowledge the concept of threat and the concept of, the threat of punishment, the threat of force, and that being a way to coerce and scare learners. So what we feel is that the bill really needs to go slightly a step further and really reiterate that schools are safe spaces and that appropriate action and punishment can be taken, but that scaring a learner, intimidating a learner, physically hurting a learner will only in the long run impact that learner's ability to engage in school, impact their ability to feel confident in the school space. And we feel that will in the long run not just be an infringement of their right in the moment, but in the long run might make them disengage from the schooling space, which will obviously affect their right to basic education.
So I'm just curious about the converse of that, and we are out of time, but I quickly want to hear you on this. So what about the converse? What about teachers who feel threatened, intimidated by learners? How should that, is that being addressed? How ought it to be addressed?
Yes, and I mean, we obviously completely understand that it is not a simplistic situation. We're not in a situation where, we have complex issues. We also understand that there's issues of overcrowding, teachers are overburdened, there are big classrooms, but we need to find a solution that doesn't require learners to live in fear or learners to be punished and teachers to live in fear and teachers to be subjected to this. And what we really feel is we need to get to the root of why these causes are happening, rather than perpetuating the issue by physically hurting or by threatening learners. I mean, although in the immediate moment, that may seem like the best way to address the issue, long term, that can't be it. But I agree with you about making sure that teachers feel safe. And that is something that we need to make sure that teachers are properly resourced, that classrooms are manageable, that there are other, resources in schools to deal with learners who are disruptive in a productive way. So we feel that the solution to this can't be to hurt or intimidate learners.
Jane Borman, thank you so much, and easing us into this, and of course it will be ongoing, and you'll have an opportunity to give your say as well. Jane Borman is Equal Education's parliamentary researcher, explaining why civil society groups in the education sector are calling for key changes in the BELA Bill as Parliament considers making the biggest amendments to basic education laws in the past decade.